A Sunday morning in a hotel parking lot, you're loading your car for the drive home. Your lawfully owned firearm is in its case in the trunk. A patrol car rolls by, the officer slows down, makes eye contact, and pulls in behind you. Nothing illegal has happened. But in that moment, your next move, your tone, even the way you reach for your registration, could determine whether this ends with a polite nod or something much worse. Most people think the law protects them clearly in moments like this. It doesn't always work that way. If you own firearms, or if you just believe rights should mean something real when pressure hits, you need to understand how courts actually decide whether force against you was lawful or not. Because for years, the system wasn't looking at the whole picture. It was zooming in on a single frozen moment and calling that justice. That just changed. The Supreme Court recently made a unanimous call that flips the script on how excessive force cases get judged. It's not about gun rights directly, but it touches every armed citizen in America. And if you stick with me through this, you'll see exactly why this matters to you and what it means the next time you interact with law enforcement. This is the kind of shift that doesn't make flashy headlines, but it rewrites the rules quietly and powerfully. Here's the setup. For a long time, when someone sued police for using too much force, courts used a really narrow lens. They'd ask one question. Was the officer in danger at the exact second they pulled the trigger or threw the punch? If the answer was yes, case closed. It didn't matter what happened 10 seconds before. It didn't matter if the officer created the danger. It didn't matter if the person was cooperating right up until things went sideways. All that mattered was that single snapshot in time, the moment of threat. If threat existed in that moment, the use of force got a pass. That's how it worked in a lot of federal courts, especially in circuits that handle huge portions of the country. Now let's talk about what people commonly believe versus what actually plays out. Most folks think the Fourth Amendment protects them from unreasonable searches and seizures. That's true on paper, but in practice, when force is used, courts weren't really asking if the whole situation was reasonable. They were asking if the final moment was scary enough. So you could have an officer approach someone who's calm, escalate the situation with confusing commands or aggressive positioning, and then when the person reacts in confusion or panic, the officer uses force. Under the old standard, courts would say the force was fine because in that last second, the officer felt threatened. The buildup didn't count. The context was invisible. And that created a gap between what the Constitution promises and what people actually experienced. This isn't a partisan issue. It's a reality issue. If you're legally armed and an officer misreads your body language, or if you make a sudden move to grab your wallet, or if you're just nervous because you know you're carrying and you're trying to stay calm, all of that context used to be legally irrelevant. The only thing that mattered was whether the officer felt fear in the moment they acted. That left a lot of lawful people in dangerous gray zones. You could do everything right and still end up on the wrong side of a use of force decision simply because the court refused to rewind the tape and look at how things escalated. Then came a case that forced the issue into the open. It involved a traffic stop that went wrong fast. An officer pulled someone over. Things got tense. The person tried to drive away. The officer jumped onto the vehicle and within a couple of seconds fired shots that killed the driver. The family sued, saying the force was excessive and violated the Fourth Amendment. Lower courts said no. The officer was in danger during those 2 seconds on the car, so the shooting was justified. The case went up the chain and landed at the Supreme Court. And the justices looked at how the lower courts had analyzed it and said, this isn't right. You can't judge the whole encounter by only looking at the final moment. You have to zoom out. You have to consider what led to that moment, what choices were made, what alternatives existed, and whether the danger was real or created by poor decisions earlier in the encounter. The court didn't just tweak the standard, they rejected the narrow approach entirely. They said courts must evaluate excessive force claims using the totality of circumstances. That means everything counts. What happened before the force, what the person was actually doing, what the officer knew or should have known, how the situation developed, whether the person was a real threat or just perceived as one because of assumptions or mistakes. This was a unanimous decision. All 9 justices agreed. That's rare, and it sends a strong signal. This isn't a close call or a political split. This is a constitutional correction. So what does this mean in plain terms? It means that if you're ever in a situation where force is used against you, courts can no longer ignore the context. If you were calm and compliant and then something changed because of how the officer acted, that's now part of the legal analysis. If the officer gave confusing orders or escalated without cause, that's now relevant. If you were doing something completely legal, like carrying a firearm openly in a state where that's allowed, and the officer treated that as an automatic threat, the court has to look at whether that reaction was reasonable given the full situation, not just the officer's feelings in the final second. This is a deeper, fairer way to measure whether your rights were violated. For gun owners, this shift is massive. You're more likely than most people to end up in a tense moment with police. A traffic stop where you inform the officer you're armed. A knock at your door because a neighbor reported seeing a gun. A misunderstanding at a public event. In those situations, the way courts evaluate what happens next just got a lot more protective of your rights. Before, an officer could claim they felt threatened simply because you were armed, and courts would often accept that without looking deeper. Now courts have to ask, was the person actually behaving in a threatening way? Was the officer's response reasonable given everything that was happening? Did the officer have other options? That's a game changer. Let me give you a practical example. Say you're pulled over at night. You tell the officer calmly that you have a concealed carry permit and a firearm in the glove box. The officer's tone shifts. Commands start coming fast. You're told to put your hands up, then reach for your license, then step out, then don't move. You're trying to comply, but you're confused. Your hand moves toward your pocket for your wallet, and the officer draws their weapon. Under the old standard, a court might only look at that hand movement and say the officer's fear was reasonable. Case closed. Under the new standard, the court has to look at the whole interaction. Were the commands clear? Was there time to comply? Did the officer create confusion? Was your behavior actually threatening or just nervous and cooperative? All of that is now legally relevant. That's the difference between being blamed for a misunderstanding and having your rights recognized. This doesn't mean officers can't use force. It means they can't justify force by pointing only to a single moment they helped create. It restores balance. Your right to carry a firearm doesn't mean much if courts let officers treat that right as automatic probable cause for violence. And your Fourth Amendment protection from unreasonable seizures doesn't mean much if courts ignore how a seizure unfolded. This ruling ties those protections together in a way that makes both stronger. Now, this ruling is going to ripple out across the country. Federal courts in every circuit have to follow it. That includes circuits that have been using the narrow moment of threat rule for years. Cases that were dismissed or lost under the old standard might get reopened. New cases will be argued with this broader framework front and center. Lawyers representing people harmed by excessive force now have a Supreme Court opinion they can point to and say, you have to look at the whole story. That's not optional anymore, it's the law. Police departments are going to have to adjust training. Officers will need to understand that their decisions before using force will be scrutinized just as much as the moment they pull the trigger. That's going to change how encounters are handled on the street. Think about the bigger picture here. For years, there's been tension between the idea that you have constitutional rights and the reality that those rights felt weak when tested. People would say, I was doing nothing wrong, I was cooperating, and courts would say, well, in that final second, the officer felt threatened, so tough luck. That gap bred frustration and distrust. This ruling doesn't fix everything, but it closes that gap significantly. It says your rights are supposed to protect you through the whole encounter, not just in theory, and it gives courts the tools to actually enforce that. If you're someone who trains regularly, who takes self-defense seriously, who studies the law because you want to stay on the right side of it, this is one of those decisions you need to file away mentally. Because if something ever goes wrong, if you're ever involved in an incident where force is used, this ruling could be the reason a court looks at the full truth instead of a frozen moment. It could be the reason your lawful actions are understood as lawful, not twisted into justification for harm. That's not a small thing. That's the Constitution doing what it's supposed to do. Let's also talk about what this means for accountability. Officers who act reasonably, who de-escalate, who give clear commands and respond proportionally, have nothing to fear from this standard. In fact, it protects them too, because the full context will show they handled things well. But officers who escalate unnecessarily, who create danger through poor tactics or assumptions, will now face real scrutiny. That's not anti-police. That's pro-Constitution. It's about making sure power is used responsibly, and that when it's not, there's a remedy. Every responsible gun owner should want that, because the same standard that protects you from excessive force also reinforces the idea that rights come with responsibility on both sides of the badge. This ruling also sets up some interesting possibilities going forward. We might see more lawsuits succeed that would have failed under the old narrow rule. We might see settlements increase because governments know courts will now look deeper. We might see changes in how police unions and departments approach use of force policies. And critically, we might see more clarity in the law about what it means to carry lawfully in public. If courts have to consider context, they also have to consider that millions of Americans carry firearms every day without incident. That lawful carry can't be treated as inherently suspicious or dangerous just because an officer feels uncomfortable. The totality of circumstances includes the fact that carrying is a right, not a crime. Here's something else worth understanding. This decision wasn't driven by ideology, it was driven by logic. The justices looked at how courts were applying the Fourth Amendment and realized it had drifted away from the text and history of the Constitution. The Fourth Amendment protects against unreasonable seizures. A seizure isn't just the final moment, it's the whole event. So, judging reasonableness by ignoring most of the event made no sense. The court corrected that. And because it was unanimous, it's harder for lower courts to dodge or narrow the ruling. This is going to stick. Now, what should you do with this information? First, understand that your behavior during any police encounter still matters a lot. Stay calm. Follow clear commands. Communicate clearly about whether you're armed. Don't make sudden moves. This ruling doesn't protect reckless behavior. It protects lawful behavior that gets misunderstood or mishandled. Second, if you're ever involved in a situation where force is used against you or someone you know, make sure your attorney understands this case. It changes how the case should be argued. The full timeline, the full context, the full set of facts, all of it is now supposed to be part of the legal analysis. That can make the difference between winning and losing. Third, share this knowledge. A lot of gun owners don't follow Supreme Court cases closely. They focus on Second Amendment rulings and miss cases like this that affect them just as much. The more people know about how their rights actually work in practice, the better protected those rights become. This is also a good moment to think about the relationship between rights and reality. The Second Amendment gives you the right to keep and bear arms, but that right exists in the real world, where you interact with other people, including law enforcement. The Fourth Amendment is what protects you during those interactions. It's what keeps the government from treating you like a threat just because you're exercising a right. These amendments work together, and this ruling strengthens that partnership. It says you can't have one without the other. You can't tell people they have a right to carry and then let courts ignore context when that right leads to conflict. The Constitution has to be whole and consistent. That's what this case restores. Let's bring this home. You started this video standing in a parking lot, loading your car, legally armed, watching a patrol car pull up behind you. Now you know that if that encounter goes sideways, if the officer misreads the situation, if force gets used, the court that reviews it has to look at everything. Not just the final moment, not just whether the officer felt scared, but whether the whole situation, from start to finish, justified what happened. That's a stronger shield than you had before. It's not perfect. Courts still have discretion, officers still have tough jobs, but it's fairer, it's more constitutional, and it's the law now. If this kind of deep dive into how rights actually function in the legal system is valuable to you, then you're in the right place. This channel exists to cut through the noise and give you the real story on laws that affect your life. Not hype, not fear-mongering, just clarity. If that's what you're looking for, subscribe. Because cases like this don't get covered much elsewhere, but they matter more than most of the stuff that does. And if you've got thoughts on how this ruling might play out, or if you've had an experience where context mattered but wasn't considered, drop a comment. Let's talk about it. This is the kind of conversation that makes all of us sharper and better prepared. The bottom line is simple. Your rights are only as strong as the court's willingness to enforce them fully and fairly. For too long, excessive force cases were judged by a standard that ignored reality. That's over. The Supreme Court just told every court in the country to look at the whole picture. And for gun owners, for anyone who values the Constitution, that's a quiet but powerful win. Stay informed, stay lawful, and stay ready, because the rules just shifted in your favor.